Welcome back. A decision by the State Finance Board this week overturned the ruling of Financial Institutions Division Commissioner George Burns, who ruled Bank of Nevada would have to change its name. The bank merged with an Arizona financial institution, no longer has a charter in Nevada. Here's the state law the commissioner relied on when he made his decision. Nevada defined, Nevada when used to modify, the word bank or the term depository institution means organized under the laws of this state, and the term national bank means having its headquarters within this state. Mr. Silva, you're very familiar with this issue. Why should you be able to be called a bank with a Nevada name in it if you don't have a charter in Nevada?
Well, according to the Nevada legislature and that law you just cited, you shouldn't.
Right. And the commissioner, people don't know what the Board of Finance is. They've never heard of it. It has some elected officials on it, including the governor and the treasurer and the controller, I believe. The governor recused himself in this vote. We're going to look more into that. But the commissioner seems to be right here. There was lobbying that went on afterwards. Doesn't this open the door now for banks to not have to change their names, even if they don't have a Nevada charter anymore?
Yeah, that's correct, and I think that's really the precedent that George Burns was trying, as the commissioner, was trying to avoid. I mean, having Nevada in your name meant something to him and means something to other Nevada chartered banks who have the word Nevada in their names. It means that there's a local connection. It means that there's accountability locally, and not in Arizona or California or some other place where that bank might be now owned. It does open the door for that, and it's a consumer issue, I think, that George Burns was trying to make when he appealed this.
Well, when you say it's a consumer issue, you think he thought it might be misleading to consumers? And if so, what's the big deal to the average consumer going to a bank? How would this affect them?
Well, I think it affects them if they think that Nevada is a stronger state. If an organization is licensed in Detroit, for example,
good example. Yeah.
They may not feel as comfortable going to Bank of Nevada, owned by a Detroit banking subsidiary, whereas if it does have Nevada in their name, you know, I think they do feel comfortable because the state still is pretty strong in relation to the financial security of the deposits.
So now a bank could theoretically, based on the ruling, if this is precedent setting by the Board of Finance, which overruled the commissioner, a bank that has Nevada in its name does not necessarily have to have a Nevada charter, could sell out to some big national bank chain, but still pretend essentially, because it's essentially not truth in advertising anymore, to still be chartered in Nevada by having Nevada in its name.
That's correct, and I think that the other problem was that Western Alliance Bancorp, which is the company that acquired Bank of Nevada some time ago and now merged it in with their own bank, so it became an Arizona-based institution because they're now part of that Arizona company. They had agreed with the Financial Institutions Division and George Burns to select another name. And then they reneged on that and came back and asked for the appeal to this financial board.
Since these laws are somewhat arcane to me, I mean, doesn't, for instance, Nevada State Bank have owned by a company that's out of state? No, do they still have a Nevada charter, but they're owned by somebody out of state? How does that work?
Well, they're a subsidiary, but that institution had that name a long time ago and continued to operate under it, and it's not merged in with Zions Bank Corporation. That's a separate institution.
So they still have a Nevada charter then?
They do.
And so the question is now, what does Burns do? I mean, what's his authority in these matters now?
Well, I don't think he's going to do anything. I think he wanted to make the point that he was upholding the law, which is what his charge is as the commissioner, and I think he made that point. Whether or not it went somewhere else, that certainly is not anything that he can appeal. I mean, obviously, if there were other community banks that had Nevada in their name, they could go to court, presumably, and ask the judge. It does
open a can of worms. We're going to keep looking into it. I'm sorry we're out of time. Jeff Silver, always a pleasure seeing you. Thanks for coming on the program.